Oh, well, good evening. Good evening, good evening, good evening. We are going to try this one more again. Sorry, everyone, about earlier. Uh, my earlier live. Sorry about that, everybody. I appreciate everyone who sent a little something to the Cash App for the PA trip. If you sent a little super chat during the last live, truly appreciate you. Sorry about that last one. I'll let some notifications click in. Hopefully, everybody's having a great Friday. Let's try this one more again. Oh, well, Meg P, hello, darling. How's my audio, honey? I am not using, I'm actually using my headphones and I'm hoping it's just a little bit better. There's something going on with my shit. Yes, yay, I'm back. I'm back. I told you guys I'd be back. I tried to come back earlier, but my shit got all messed up and I'll get home, try messing with everything, and then I just set it for like 6:30. So we'll let notifications click in. Everything sound good? Thanks. Nothing half-assed. Hello. Hello. Donna, Salamander, hello. Michelle, hello. How are you? Thanks, Meg. Appreciate you, honey, so much. I figured, well, for fuck's sake, we'll try this again. You know what I mean? I don't even know where I left off. I was trying to show you and shit went sideways. I know we got to Maggie Sanders, and that was about as far as we got. So anyways, Miss Q, hello. All right, so I think we left off on the PA website. I got to show you guys Maggie Sanders, who she is. There was an article out of the Pleasant Valley School District, whatever, that shows that Maggie Sanders is the school psychologist there for what appears to be the elementary school district, I believe. Don't quote me though. You know, she's listed as a school psychologist. Sanders asked for a continuance for Monday's hearing in Pennsylvania due to the fact country, the law that the defense has hired, it's like McCracken or McCracken or some shit. They're the ones who issued the subpoenas on behalf of the defense for the people in Pennsylvania. Maggie Sanders is one of them. The law firm and Maggie Sanders' attorney agreed since she's out of the country, won't be back until July 6th. She was seeking a continuance for any day after July 6th, and the Monroe County Court ordered July 7th promptly at 9 a.m. She must appear in court. So they did not give her much time to get back from being out of the country, and she must appear promptly at 9 a.m. on July 7th. So that's about as far as we got. And then there's a couple of other things I wanted to review with you regarding the upcoming hearing Monday, which I will be at. So that's why we're going to review it. And then, yes, we're going to get into the motion regarding the alternative perpetrators and the motion to continue. God willing, if the fucking internet and the spooks allow me to get through this live tonight, that's what the plan is, friends. Appreciate everybody being here. Welcome to everyone just coming in. If you missed the earlier live, it wasn't long. It's like 30 minutes. Maybe put it at 2 speed so you can catch up. You didn't miss much, but there was a couple things regarding Pennsylvania we did review. Oh, well, for fuck's sake, Fitziana, hello, welcome on in, darling. You got my text, right? Um, certain words, you know. So Fitzy knows what I'm talking about, okay? I just want to make it clear to everyone in my chat, especially if you're new here, sidebar, okay, sidebar, before we get into this. Over here, we're adults, and adults use words like murder, homicide, rape, trafficking, sexual assault, okay? So as much as I don't like to stir the pot, I'm gonna fucking stir it a little bit, just a little. If there are words like the atrocities, the unalivings, the incident being used in chat, fucking delete that shit. You don't have to boot the person. You don't have to like ban them, but remove the comment because I'm just not in the mood. Over here, we use adult words because we're talking about a goddamn quadruple homicide here. And I'm not walking on eggshells or tiptoeing around actual factual words that the investigators use, that the defense uses, that the state uses, that the media uses. Okay. So, mods, if you see anybody for any reason using the words, atrocities, unalivings, remove that shit, please. And thank you. I say murder. That's what it is. These are 4 murders, 4 homicides. This was a quad hom, right? So I understand that there's a lot of people and creators or whatever. I'm not knocking anybody, okay? It's just that there's a lot of creators out there that for whatever reason will say that like they're going to get demonetized, they're going to get this, they're going to get that. These people have tens of thousands of subscribers, if not more, and they're not demonetized. The rest of us are out here. We don't have as many, we have a couple thousand. We're monetized. We're not getting strikes. We're not. YouTube isn't telling us, oh my God, you can't say these words. It's just not true. It's just not true. I've never once been told by YouTube that I can't say the word murder. Okay? Ever. I have never been told by YouTube that I must use the word unaliving or atrocity or incident or something besides the word homicide. I've just never been told that. So maybe, hey, I'm not a real YouTuber though, right? So, and I don't know shit. So I'm just saying, okay? I'm an adult. We're all adults here, and I think that we can use adult words, especially when the state uses them, the defense uses them, the court uses them. They're in court filings. We are reading court documents. I'm going to use the words. I'm going to use the actual words. I'm not going to say unaliving or atrocity or incident or anything else. So just wanted to clear that up. Mods, love you. Thank you. We don't have to ban anybody. It's just people come in and they're like, I've seen some of my comments too that I'm just like, what in the actual fuck, man? Can you just say the word murder? Right? Can we just all speak like adults here? I mean, yeah, I guess you could say it. I've said it before, Rui. Sure. What about cunt? I mean, yeah, go for it. I think if you tried to leave it in a comment, YouTube would probably flag it and I'd have to allow it. But even then, I don't know. I know they're weird about the comments, but like when it comes to reading court documents, if there's a word in a court document, like for example, homicides, I'm going to say homicides. I'm not going to, be a bush beater, you know? So I just wanted to clear that up because I've been going through my comments section lately and the amount of if I had $1 for every time I read the word atrocities, right? My swear jar would be full. We'll just say that. If I had $1 for every time I saw the word atrocities, the atrocities in my comment section, my fucking swear jar would be overflowing. Know what I mean? So, anyways, let's get to this. Enough of my bullshit. Enough of me running my mouth. Wade Bird, hello. Colder covered, hello. Welcome on in, darling. So good to see you. Thanks everybody for being here. If there's anyone I missed, I'm so sorry. Would never mean to miss anyone. Mercy Cat, if you're in here somewhere, I love you. All right. For fuck's sake, Fitziana, I know you're here. Where's Twiz? Tokane and Twiz, I said hello. Okay, so let's get back over here real quick. Yeah, no shit, right, Miss Q? For the love of God. If I see it mentioned in a doc, then maybe I'll hop on that bandwagon. But I mean, I have yet to see anything anywhere about the that they're drug dealers, that like it's just wild to me. It's just wild. I could understand if somewhere in a document somewhere uh, drugs, drug dealing were implied, even just a little bit, like by Sith or the defense or one of their, but I haven't seen it. I literally haven't seen it. So until I do, um, I mean, I'm just not going to roll with it. Momo's thinking, well, holy guacamole, haven't seen you in forever. Welcome on in. Good to see you. Always good to see you. Haven't seen you in forever. Yes, meow, Mercy Cat. Rawr. All right, so I just wanted to show you guys a couple things out of PA real quick, and then we're going to get into the good shit. Oh, I also wanted to look at Meister just because, fucking Hippler, the hypocrite over here, cites it, so might as well look at it. But I also don't even. All right, let's get into this. So, as we can all see here in the description of the video, if anybody needs them, print them, laminate them, frame them, and don't forget to give it a fucking thumbs up. As you can see here, Commonwealth v. Kohberger, we have everything that started like, so now we know all of those Washington subpoenas, it would appear, started right around second, if I remember correctly. I don't have it up in front of me. So don't quote me. Then again, I don't know shit. No facts here. As I always say, if you're new here, that's just me being no facts here, right? Even though I'm going to share everything with you. And the docs, do not take my word for it. Look it up yourself. Come to your own conclusions. So as we can see, if I remember correctly, June 2nd is when the Washington subpoena started going out. And then June 4th, they started hitting the Pennsylvania docket as well. We've already seen these petitions, the summons for Vecchio, that is the used car dealership guy that sold Bryan the white Elantra. We have Andriola, already discussed Brandon Andriola. Let's see, we went over the decorum order, or if we didn't go over it, I probably posted it. If you want to read that, it's over there. Here we go. Maggie Sanders. So this is what we got to in the earlier live. We got to see the agreed motion between McCracken and Sanders's attorney here. Let's get into Parham. So we have the summons for Parham. Hang on. I have to probably stop sharing that and then share this instead. My bad, friends. Un momento, por favor. Hopefully my audio's holding up, man. KB. What up, KB? Just saw you, homie. Out of the corner of my eye. And now my shit's telling me lost connection. Fuck off, restream. All right, hopefully you guys can see this. You can't. Hang on, it'll catch up. All right, here we go. So this is Parham. It's 6 pages. We'll get into it real quick for witness and Parham. June 25th, 2020. Upon consideration of the petition for summons directing witness Ann Parham to an out-of-state criminal proceeding, Judge Stephen Hippler sealed certificate pursuant to 42 PACS blah blah blah. The agreed motion to summon witness Ann Parham and cancel hearing on the petition for summons and the declaration of Ann Parham filed in support thereof, the court finds as follows. 1. Ann Parham is a material and necessary witness in a criminal proceeding pending before the District Court for the 4th Judicial District of the State of Idaho. 2. Compelling the attendance and testimony of Ann Parham will not cause undue hardship to her. 3. The laws of the State of Idaho, where the prosecution is pending, and of any other state through which Ann Parham may be required to pass by ordinary course of travel, provide protection to her from arrest and from the service of civil or criminal process while traveling to attending and returning from the proceeding. For these reasons, it is hereby ordered as follows. A summons is issued, blah, 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 and Parham is ordered to attend and testify in the court proceedings pending in the state of Idaho before the Honorable Stephen Hippler of the District Court of the 4th Judicial District of the state of Idaho on the dates of trial. The trial begins on August 11th and ends on November 7th. The specific date for her appearance shall be communicated to Ann Parham by Judge Hippler or Ann Taylor Law. And then as we can go in through this, so Abigail Parnell is her attorney. I don't like it that it has address, but there's nothing I can do about it. This is her certificate of service, okay, which is interesting because it's the ex parte sealed certificate of an Idaho district judge that Pennsylvania, they don't seal shit. And they don't even redact. They'll just give you everybody's name, address, sealed. Thanks, PA. They won't give them your fucking body cams, though. Pennsylvania won't give you their body cams, but give you everybody's name, address. They don't give a fuck. All right, so pursuant to Idaho Code, blah, 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 and after considering the motion of the defendant and the affidavit of Elisa Massif, the District Court of the 4th Judicial District of the state of Idaho in and for the county of Ada, being otherwise fully advised, hereby says as follows. 1. The 4th District Court in Ada County is constitutionally and statutorily a court of record in the state of Idaho. 2. There is a criminal proceeding pending before this court at case number blah, blah, blah. 3. The defendant in this case is charged with 4 counts of a murder. Notice it doesn't say sidebar. Notice Hippler here doesn't use the word unaliving or incident or atrocities. The defendant in this case is charged with 4 counts of a murder in the first degree, Idaho Code, blah, 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 and 1 count of burglary, Idaho Code, blah, 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 under Idaho law that is punishable by death. 4. I am the judge assigned to preside over the trial scheduled to begin on August 11th, 2025 at 8:30 a.m. through November 7th, 2025. Number 5, Ann Parham, a person within the Commonwealth of Pennsylvania, is a material witness in this case for the defendant. 6. For the reasons stated in the affidavit of Elisa Massif, the presence of Ann Parham is required at the Ada County Courthouse in Boise, Idaho. 7. Ann Parham's presence is required for 2 days. 8. Under the laws of the state of Idaho, if Ann Parham comes into the state in obedience of a summons requiring his presence at trial, he will not be subject to arrest or service of any process relating to matters that arose before he entered the state under the summons. 9. This certificate is made for the express purpose of being presented to a judge of a court of record in the state of Pennsylvania instead of an order to compel the attendance of Ann Parham at the time and place, and for the reasons stated above. Now, notice here, Hippler signed this March 13th, bro. And it was given under, given under my hand this 14th day of March 2025, clerk. So Hippler filed this March 13th, but yet Miss Parham and the rest of them weren't served until June. Wait, what? What do you mean the mods have no power? What do you mean? Hang on. I'm just seeing my chat, Fitzy, so I'm probably just it's probably something you're talking about with someone else. Sleuthy sweetheart, hello. Hi, everyone. If you're just joining, welcome, welcome. JJ, what up? Welcome on in, homie. Good to see you, good to see you, as always. If there's anybody else I missed, sorry, Kane. I know I didn't miss you. Hello, everyone. So it's interesting that he signed this on March 13th, huh? But yet these things didn't even go out until, let's see, June 25th. No, June 25th is when they agreed, if I remember correctly. She was served and then they agreed. This is why she will not be attending the hearing on Monday and she doesn't have to show up on Monday, is because they've already agreed that she will attend out in Idaho. But as you see here, this was signed March 13th, 2025. So interesting, huh? March 13th, 2025. Hippler already signed this. Hmm. Okay, stop sharing that. Get out of there. Let's come back over here. Was it that one? Sorry, friends. Give me 1 second. I think it was this one. Yeah. Okay. So, I'm going to look at this one. This is also related to Parham for Monday. Okay. Up, friends. My mic sound okay? Everything seemed to be going smooth? Or has it been clipping out and acting all kinds of shady? Before I get going too far into this, huh? I should probably do a audio check. If you remember to smash that thumbs up on your way in, give it a thumbs up, give it a thumbs down, follow your heart. That's what you should do. Follow your heart. I'm so excited about going to PA on Monday. I don't think you guys even understand. I'm super excited to sit in for this hearing on Monday. Even though Anne has agreed she's going to go out to Idaho to testify, there's still 6 other people. Or no, technically 5, because the other one got continued until July. I'm Gucci. Thank you. Thank you, Kane. I'm not using my mic, the fucking new mic I just got. Yeah, not using that. I think it's the mic, to be honest with you. I'm gonna have to take it back and get a different one. Okay, so this one here, this is the motion. The agreed motion. So this is why she's not, this is why it's been agreed. She doesn't have to attend on Monday. Both sides agreed. And Parham's attorney, along with the fucking MacGyver, McCracken, fucking whatever the attorney's name is out of PA that sent out all these subpoenas for the defense. Let's see. Agreed motion to summon witness Ann Parham and cancel the hearing on petition for summons for Ann Parham. So we read something similar in the previous live today for Maggie Sanders. Basically, same thing. June 5th, right? So Hippler signed off on all these fucking subpoenas, by the way, like March 13th. But they're not even going out until like June 2nd, June 3rd, June 4th is when people are being served. Kind of wild that they were sat on. March, April, May, June, going into June. So what, 3 months he sat on this shit? Why would that be? Why would that be that you know that you're going to issue these subpoenas, but you're also sitting on them for a couple months? I mean, I don't know. I don't know shit. I'm just asking questions, It's just questions. So on June 5th, petitioner filed a petition for summons directing witness Ann Parham to attend and testify in an out-of-state criminal proceeding pursuant to blah, blah, blah. Seeking to domesticate an out-of-state subpoena issued in the matter of State of Idaho v. Bryan Kohberger, currently pending in the 4th Judicial District Court of the State of Idaho. Docket number blah, blah, blah. As required by blah, 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 attached to that petition were the sealed certificate of Judge Stephen Hippler of the District Court for the 4th Judicial District of Idaho and a subpoena signed by Judge Hippler, directing Parham to attend and testify during the Idaho criminal trial, which is scheduled to begin on August 11th and continue through November 7th, 2025. Pursuant to blah, blah, this court scheduled a hearing on the petition for June 30th. to determine whether the statutory requirements are satisfied, specifically whether Parham is a material witness and whether compliance with the subpoena will not cause her undue hardship. Read this the other way, read this first and what I read but it's okay. I'm sure you get, hopefully you're fucking smart enough to get where this is going. The certificate of Judge Hippler states that Parham is a material witness in the Idaho proceeding. Under 42 blah blah blah, such a certificate constitutes a prima facie evidence of materiality. Did I say that right? Prima facie, prima facie, prima facie. I don't even know, and I'm not going to Google it. Don't care. On June 16th, 2025, Parham executed a sworn declaration attached hereto as Exhibit A. Oh, well, we got another fucking Exhibit A, in which she affirms the following. A. She was served with and has reviewed petition for summons directing witness Ann Parham to attend and testify in an out-of-state criminal proceeding, the order scheduling the June 30 hearing, the sealed certificate of Judge Hippler, and the subpoena directing her to attend and testify in the Idaho criminal trial. Parham declaration, blah, blah, blah. She is a material witness in the criminal proceeding. She agrees. She literally agrees in her declaration. She is a material witness in the criminal proceeding. Compliance with the Idaho subpoena and attendance at trial will not cause her undue hardship. She's saying, nope, it's fine. I will attend. It will not cause me any financial or undue hardship. And I agree, I am a material witness for the defense. In the declaration, Ms. Parham knowingly and voluntarily waives her right to a hearing under 42 blah blah and consents to this court entering an order summoning her to appear and comply with the Idaho subpoena. Given the representations in Ms. Parham's sworn declaration and the certificate of Judge Hippler, the purpose of the hearing, meaning to evaluate witnesses' materiality and potential hardship, has been satisfied by her express waiver and the supporting statutory presumption of materiality. Petitioner respectfully avers Petitioner respectfully avers that the hearing currently scheduled for June 30th is unnecessary and may be canceled without prejudice to the rights of any party or the authority of this court under 42 blah blah blah. Wherefore, petitioner, by agreement with Miss Ann Parham, respectfully requests that the court 1. Enter an order summoning Ann Parham to appear in the state of Idaho in accordance with the out-of-state subpoena and 42 blah blah blah, and 2. Cancel the hearing scheduled for June 30th on the petition for summons. And then there you go. Montgomery, McCracken, Walker, and Rhodes. I think I said MacGyver, McCracken, and something. It's Montgomery, McCracken. MacGyver, McCracken. That would be a pretty cool fucking name, though, for a law firm. Montgomery, McCracken, Walker, and Rhodes. June 16th, 2025. Okay, great. And then Exhibit A. We have the declaration here of Ann Parham. How's chat doing before we get into Miss Ann's declaration? Miss Ann Parham, it bounces back and forth. Yeah, YouTube's doing some weird shit. Got my headphones on. What, is my audio messing up? What in the actual fuck? Hang on. Give me a second. Let me just check something. Mic check. 1, 2, 1, 2. Piece of shit. Mic check. 1, 2, 1. Piece of shit. Let's try this again. I don't even have my volume up high. We'll turn her down a little more. Maybe it's because my thing is right up to my mouth here. Leslie and Billy, hello. Why be so nosy? Hello. So, hopefully my audio's holding out for you guys. Tonka, what up? Kickbait, what up? Come on in. Pool, welcome on in. Let me grab my drink. Sorry. It's all good? Oh, okay, cool. Thank you. Sorry. I thought you guys were letting me know that my audio is, like, bouncing back and forth and shit. I was like, "Of course it is. Why wouldn't it be, darling? That's what it does." You know what I mean? That's what this shit does around here. It just likes to toy with me. Alright, so that wasn't a text saying, "Hey, girl, your shit's going down in flames." Okay, cool. Alright. So, let's get into the declaration here of Ann Parham, and then we'll get over to the Idaho docs, friends, I promise. I just wanted to get into some of these PA docs and do a quick little catch up because of what's coming up for the hearing on Monday. That's all. And then we will get into Hippler's bullshit. Sleuthy sweetheart, have a great show. Yeah, have a great show. You're going live? I think Dinky's going live soon too, so, I'm not gonna try to be on here all night. It is what it is. I got a lot of packing and stuff to do tomorrow because we get on the road early Sunday morning. So tomorrow is I spent the day cleaning my house, finishing laundry, all that good stuff. I'm gonna spend the day tomorrow packing, and then we get on the road early Monday, so I ain't trying to be here. It's spooks or solar flares. Yes, correct. For fuck's sake, Fitziana. I think it's spooks because it's only me. I've watched other people go live today and they didn't have any problems. Like their chat was messed up, but mine always seems to be my audio. They actually literally fuck with my audio while I'm reading docs. That's what I think. I don't care. I'll adjust my tinfoil hat. It's spooks, in my opinion, and they need to get a life. So let's get into the declaration here of Ann Parham. I, Ann Parham, being an adult individual residing in Monroe County, hereby declare as follows. 1. I was served with and have reviewed the petition for summons directing witness Ann Parham to attend and testify in an out-of-state criminal proceeding filed in this matter on June 5th. So March 13th, he ordered it. It goes to her June 5th, as well as the court requiring me to appear for a hearing on that petition, currently scheduled for June 30th. 2. I was also served with and have reviewed the sealed certificate of Judge Stephen Hippler of the District Court for the 4th Judicial District of the State of Idaho and the subpoena issued by Judge Hippler, which requires me to attend and testify at trial in the matter of State of Idaho versus Bryan Kohberger. That trial is currently scheduled to begin on August 11th, 2025 and continue through November 7th, 2025. I knowingly and voluntarily waive my right to the hearing provided under 42 blah 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 on the issues of materiality and undue hardship. I further consent to this court entering an order summoning me to appear and comply with the Idaho subpoena, including my attendance and testimony at trial in this matter. I affirm and declare that A, I am a material witness in the referenced criminal proceeding, and B, complying with the Idaho subpoena and attending the trial will not cause me undue hardship. I am making this declaration voluntarily and of my own accord, and I affirm that I was not asked or encouraged by the petitioner or anyone acting on the petitioner's behalf to waive my right to a hearing. And then she signs it, 16th day in Monroe County, blah, blah, blah. And her attorney, Abigail Parnell, signs off on it. As you can see here, this is okay, everything else that goes along with it. Links to this are in the description of the video. If anyone wants it for themselves, you can go look at it, print it, laminate it, frame it, whatever. Get out of there. Now, was there one more thing? No. Okay, cool. So we went over everything for PA. I can close that out. Let's look at this real quick. Just want to review Meister. We're going to do it quickly. Happy Friday, everybody. Happy hip, 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 hooray. It's Friday. Hope everybody's going to have an awesome weekend. Stay safe, stay hydrated. Don't forget, check on your elderly, check on your animals. Please don't take your animals out in the very hot cars with you either. Okay? If it's really, really hot, just leave them at home in the AC, I promise. It's okay. Who is Miss Parham? Well, if I remember correctly, Miss Parham is the teacher who used to work for Pleasant Valley School District. She's retired now, but she worked with all of the gifted students. And then Maggie Sanders was the school psychologist, if I remember correctly. But don't quote me. No facts here. I don't know shit. Do your own research. So, yeah, that's what I thought. Yvonne, thank you. Let me take a sip of my drink. Do we need to make sure Heather Fitzgerald is hydrated? Of course, as always. I'm just saying, stay hydrated. If you're going to bring the dogs out, bring plenty of water for them too. Heat stroke can happen to a dog very, very, very quickly. Very quickly. They overheat very quickly. And then once their body temperature gets too hot, it has a very hard time re-regulating it back down to where it's supposed to be. And it's awful watching a dog overheat. It's awful. So just saying, just my little warning. Please leave the doggos in with water and ice cubes and AC and fans blowing on them. You know, treat them like the royalty that they are. That's my motto. There are angels here on earth, whether we know it or not, just in a different form, in my opinion. So, anyways, all right. Now we can get into, let's just look back at this real quick. Yeah, they are, Rui. Well, I have my own opinion as to why I think that. Um, and it's redacted in Hippler's order, but if what I think is in that redacted portion, then it totally makes sense in my mind. A, why it's redacted, and B, why they want it. Um, but I'm going to keep that to myself um, until further notice. For fuck's sake, Fitziana knows exactly what I'm thinking, but I'm going to reserve my opinion on it until I can see the unredacted version. If we get to see it, we may not. Just because if it is what I think it is, um, we wouldn't even get to hear about it until trial anyway, and it would be at the mitigation stage. But that's just my opinion. Oh, there you go. Good for you, chick babe. 10 to 12,000 steps a day. Yes, good for you, darling. Yes, right? They are angels with paws. Jen, hello, beautiful Jen 7S, Gen S, OG. Okay. All right, guys, I'll shut up. I'll shut up. There are, people in the chat are like, come on, bitch, just read the docs. Why you always got to talk about dogs and shit? Annie and her bullshit all the time. Can't she just read the docs? God. No, bitches, you're still going to have to wait a little longer because I'm going to read Meister first. Anyways, we'll do it quickly. All right. So we don't need the factual, I don't think, and procedural background, okay? Uh, Basically, what this comes down to is in 2001, a woman was shot and killed in her home that she shared with her boyfriend, okay? Based on footprints in the snow, it was determined that it approached from the front entrance to the woman's home and then proceeded to the back entrance. When the woman opened the back door, she was shot once in the chest and once in the face and retreated behind the home through a snow covered field, which exited onto a nearby road. A neighbor heard the shots and went to the woman's home. He called 911 and unsuccessfully made resuscitation efforts. She was pronounced dead at the scene. Almost a year later, police officers interrogated Meister. Okay, Meister is the person. Okay. David Meister. Officers interrogated Meister. This is almost a year later after the crime in connection with the woman's death. Meister confessed that he was paid $1,000 by the victim's boyfriend to kill the victim. Meister was charged with first-degree murder and conspiracy to commit murder. Prior to trial, Meister filed a motion to suppress his confession, which the district court denied. A jury convicted Meister on both charges, and Meister appealed. On appeal, this court determined that the district court did not err in admitting Meister's confession. However, the court concluded the district court did err by not admitting evidence of an alternate perpetrator. The state petitioned the Idaho Supreme Court for review regarding the alternate perpetrator issue, which the court granted. The Idaho Supreme Court held that the district court applied the wrong standard for admissibility of alternate perpetrator evidence. They vacated Meister's judgment of conviction and remanded the case for a new trial. Preceding the second trial, the state filed a motion regarding the law of the case doctrine, requesting that the district court limit relitigation of any issue addressed on appeal by either this court or the Idaho Supreme Court. The district court granted the motion in part and denied the motion in part, ruling only issues addressed by the Supreme Court were precluded from relitigation. In addition, the district court applied the law of the case doctrine to all unappealed rulings of the district court unless there was a showing that the decision was clearly erroneous and a manifest injustice would result. Meister then filed another motion to suppress his confession, arguing it was coerced. After a hearing in which Meister's expert witness, Dr. O, provided testimony regarding the coercive nature of certain interrogation techniques, the district court ruled Meister's confession was not coerced and denied Meister's motion to suppress. The state filed a motion in limine to preclude Dr. O's testimony, arguing that based on the district court's ruling, any testimony would be irrelevant. The district court ruled that Dr. O would be permitted to offer testimony regarding false confessions in general. However, the district court's previous ruling on the voluntariness of Meister's confession would stand. The court also ruled that Dr. O could not testify regarding the voluntariness of Meister's confession. Finally, the district court ruled Dr. O's testimony would be limited because he would not be permitted to offer an opinion regarding the truth or falsity of Meister's confession. At Meister's second trial, Dr. O testified regarding false confessions in general, including theories of how certain interrogation tactics can result in an innocent person's confession to a crime. The state questioned Dr. O about the percentage of cases he reviewed which resulted in a false confession. Meister then requested that Dr. O testify regarding the application of his theories regarding false confessions to circumstances surrounding Meister's confession, arguing that the state's questioning opened the door for such. The opening the door doctrine. The district court denied the request. All right, so during the closing argument, blah, 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 the police initially presented Meister with the evidence against him. The officer sat knee to knee with Meister. Okay, so during the closing argument, trial counsel stated the police initially presented Meister with the evidence against him. The officer sat knee to knee with Meister, attacking him for 40 minutes. Counsel argued that after hours of interrogation, officers presented Meister with the idea that Meister had been hired by a coworker to kill his girlfriend, offered Meister leniency, and said that the coworker, not Meister, was the bad person and that they wanted to help Meister. Counsel stated, quote, "That's the point from Dr. O, and that's the point you get to by doing all of the things that the officers did in their interrogation of him to result in a false confession. They made it helpless, and they provided him an out," end quote. Counsel then discussed the parts of Meister's confession that contradicted the evidence. Things like Meister claimed to see a police vehicle on a road while fleeing, when in fact, no police vehicle was on that road. Meister also confessed to throwing away the bullets as he fled. Yet several witnesses testified that Meister offered to give them the bullets in the following days. Meister also claimed he discarded his clothes in the field, yet no clothes were ever found. Counsel finally stated, quote, "The circumstances offered by Dr. O create the circumstances of a false confession," end quote. In addition, the state introduced evidence of two bullets found at the scene, one found in the wall and the other removed from the victim's body, as well as cartridge cases. Two firearms experts testified that the bullets were from a high-point 9mm semi-automatic handgun. Sidebar, shittiest gun you can purchase on the fucking planet. You killed someone with a high point, you piece of shit. Straight to jail. Straight to jail. Fucking high point. That's some weak ass shit right there, a high point. And JJ, anybody in the chat who knows what I'm talking about, you'll know. You'll know. You'll get a laugh out of that one. Sidebar, high point. You used a high point to commit a crime, you goddamn. That's like subhuman using a high point. 9mm. Jesus. For the love. A high point. I'm going to go off on my little sidebar here for 1 second. A high point, really? Whether it was Meister or not, whoever it was that used a high point to shoot a woman, I mean, you're just, for the love of God, you couldn't get anything else, literally anything else. A high point. Fucking subhuman. All right, let's continue. The bullets were remanufactured, and the bullets were consistent with those remanufactured by Ultramax. The state also presented evidence that Meister had purchased a high-point 9mm semi-automatic handgun and Ultramax manufactured ammunition days prior to the victim's death. I mean, investigate state, sidebar, state. You know how many people purchase those cheap piece of shit high points that fucking jam all the time? Know what I mean? People don't purchase those guns to commit murder for hire. That's not why you purchase a high point. It's just because maybe you're worried someone might kick in the door in the middle of the night and you don't want to drop 6, 7, 800 bucks on, a much nicer firearm. So they go buy these cheap, ineffective, unreliable fucking high points. Okay. Anybody purchasing a high point isn't a merc. They're not a hitman. This is not. Stop. I can't even believe the state argued this. Holy shit. All right. So, anyways, let me get back to my place here. Okay. I lost my place. Hang on. So sorry because I went off my fucking high point tangent. Let's see. Here we go. Okay. Let's start again. One found in the wall, one in the victim's home, and one removed from the victim's body, as well as two cartridge cases. Two firearms experts testified the bullets were fired from a high-point 9mm semi-automatic handgun. The bullets were remanufactured, and the bullets were consistent with those remanufactured by Ultramax. The state also presented evidence that Meister had purchased a high-point 9mm semi-automatic handgun and Ultramax manufactured ammunition days prior to the victim's death. I mean, hey, sounds like John Wick right here. High Point and Ultramax. Oh my God, it's John Wick. It's John Wick and a murder for hire plot. That's the state's theory. That's the state's theory that got this guy convicted. This guy's like John Wick, see? He went and purchased a semi-automatic handgun with, look, Ultramax. Okay, Ultramax remanufactured ammo. That's literally like, who bought that shit? Jurors bought that. That's not what a mercenary or a hired hitman is using ever for any reason under any circumstance because it's so unreliable. You would never use a high point ever for a murder for hire. It's just actually the dumbest thing I've ever heard. But that's just my opinion and I don't know shit. Meister admitted in his testimony that he purchased the gun, but testified that he sold the gun and ammunition to a stranger at a party the day before the victim's death. Well, Meister, either you're a liar or you're a dumbass because that thing didn't cost you more than fucking 200 bucks with the ammo. So you sold it, huh? So you're either a liar or just dumb, David Meister. Okay. Holy shit. The day after the victim's death, the gun manual and tools were found under Meister's refrigerator. The person who sold the gun to Meister testified that Meister said he was, quote, going to shoot somebody in the face, end quote. The state presented testimony that Meister offered at least two individuals a box of 9mm ammunition for free. One witness testified Meister told the witness that Meister wanted to go get rid of the ammunition because he was afraid it was used in a crime, and the witness and Meister then threw the ammunition into a dumpster. Photographs of footprints found at the scene of the crime were introduced showing prints in the snow leading from the back door of the home through a field, over some fences, and to a road. A shoe print analysis was conducted. Interesting. Showing the footprints were likely created by a size 8.5 to 9.5, and the tread design was consistent with that of an Osiris ODS shoe. Multiple witnesses. Look at that. I mean, they nailed it to an Osiris ODS sidebar. They nailed it. Osiris ODS here, 8.5 to 9. But all we got in Idaho was similar to a Vans style shoe and no size. Interesting. Multiple witnesses testified that Meister owned Osiris ODS shoes, and a shoe salesman testified that he measured Meister's foot and that his shoe size was 8.5 to 9. Well, fucking lock him up. Two people testified that they saw a person walking along the highway near the victim's home immediately before the victim's death. The person was described as male, wearing a plaid flannel shirt, dark baggy pants, and possibly a scarf, and that he walked with an unusual gait. The witnesses testified the person fit the physical size of Meister. In his confession, Meister stated that prior to going to the victim's home, he drank a couple beers, put on dark corduroy pants and a red flannel shirt, black scarf, and black beanie. Witnesses also testified that on various occasions, Meister stated whoever committed the murder must have been pretty smart to not have been caught. Meister asked one witness, quote, "What would you say if I told you I did it?" End quote. Then stated, well, quote, "Well, I did it," end quote, followed by, quote, "No, I'm just kidding," end quote. Meister also told another while watching a detective show that a coworker dollars to kill the coworker's girlfriend, that Meister walked to her house, knocked on the door, shot her in the face and chest, ran to a field where he had stashed some clothes and shoes, changed his clothes, and threw the gun and shoes in a garbage can. And then I can't get the rest of this. Hang on. So anyways, breakdown here, right? When it comes to alternate perpetrator, this case right here, if you want to go read the entire thing, all of it, go read it. I'm not going to go through the whole thing, but this case is why we have the standards for alternative perpetrator evidence, when, how it gets in, why it gets in, blah, blah, blah. It all stems from this case, from the Meister case. Okay. I'm sure all of you know that. I didn't need to explain it to the people who already know, and I know that, but just wanted to include it, and it is linked in the description for anybody who wants it. I'm sure the whole actual thing is somewhere. I found that, wanted to read it, and then my dumbass didn't realize it wouldn't open the rest of the way until it was too late. So it is what it is. You got as far as I did with it. Too fast for flea. Holy shit. Thank you so much. Look at you. You're so pretty. I really appreciate you, darling. $40 super chat. You kick ass. Thank you so very much. It's some effort, some time. It's just I've been busy prepping for PA and work and, other stuff. So I truly, truly appreciate you. And I promise you it's going to help. Okay. I really do appreciate it. Thank you so much. Too fast for fleas. You are so pretty. All right. So let's get to the rest of this because I know we need to get to the alternative perpetrator ruling and then our order. And we'll get to the order on the motion to continue. Now, I know the motion to continue is 20 something pages. I'm not going to read the thing. We're going to get to the pertinent parts. Yes, sound like a plan, Z's? Is that cool, friends? So that I'm literally not stuck here all night. I do have to get up early tomorrow. I have a lot of packing to do. I have a lot of things that I need to get ready, picking up the rental car, things like that. Okay, are we back or what? Looks like I'm still live. No idea what in the fuck just happened. I think someone hit a thing near my house. Hopefully we're still here, guys. Can you hear me? There was like this really loud boom, and then the internet went out. Like I had to literally hotspot from my phone. Didn't you? I think someone hit a pole. Everything went out. I'm back, right? Everything's working. Okay, awesome. I literally had to connect to my hotspot through my phone because my whatever happened over here, everything went out. Oh, it's YouTube, Meg? No, I don't know. Boom, where I am. I think someone hit a pole. Okay, yay. Okay, awesome. Already read, huh? All right, sweet. Michelle, hello. On in. Gina, hello, honey. Thanks. Okay, everyone's still here. Hopefully, too many people didn't bounce. They're like, oh my God, this bitch and her problems again. 20, 30, 40 people that drop out. They're like, oh my God, her and her fucking and technical difficulties. She sucks. That's why I always me to the real YouTuber standard because I'm not one. Shit happens and we it. That's right. Spook. Okay. Let's see. Get back over here. I don't even know the last of what you heard of what I was saying. I was trying to keep it to too fast for the $40 suit. I truly appreciate it. I don't know if you and now it's saying no connection again. What is happening? Hey from Vegas. Hey Annie Ruler, how you doing? Saying oops, lost connection, but there's no way. Like I'm not even on the regular. I'm on hotspot. Okay. I don't know what's happening, guys. I don't know if it's YouTube. I don't know if it's Restream. I don't know if it's Solar Flare, Skers. Who knows at this point anymore, right? Fucking assholes. We're just gonna roll with it. Um, let's get this opened. Oh wait, no, actually, I don't need it from there. I already have one highlighted that I want to use. Let's get that. This one will be quick. It's only 7. Sure, you've heard other people read it. Everybody else has already read it. I'm sure it's already been printed, laminated, framed. It's fine. We're gonna go through it together and, get it on the record. We're just gonna we're gonna preserve the record as best as we can. Okay. How we doing? Before I even start reading this, let's check. Everyone can see this? Great. Can you hear me? Thumbs it up if you can hear me. Da, 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 da. Lori, hello. Lori Jean. Good to see you. Welcome on in. Yeah, right. Satellite walkie-talkies. I know. Okay. I just need some thumbs up. Let me know my audio is good, and we're gonna roll with this because as long as you guys can see it, roll with it. For as long as we can hear me. I don't know. My chat's frozen. Fuck. go. Redacted order on defendant's offer of proof regarding alternate perpetrators. The state previously moved in limine, seeking to preclude defendant from offering or arguing alternative perpetrator evidence without first satisfying the applicable evidentiary standards. In accordance with the court's subsequent order on the motion, defendant filed his offers of proof and evidence in support, identifying 4 individuals as potential alternate perpetrators. 4 individuals. The state objects to the presentation of this evidence at trial, arguing it fails to satisfy the standard under State v. Meister. Defendant conceded at oral argument that at this point, his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests latitude in cross-examination of the state's witnesses to try to establish additional evidence to satisfy the Meister standard. Let's read that again. Defendant conceded at oral argument that at this point, his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests in cross-examination of the state's witnesses to try to establish additional evidence to satisfy Meister. Basically, that means we get to cross-examine all of the state's witnesses, and we still get to present our theory, which is, well, multiple suspects, multiple weapons. So they want latitude in cross-examination of the state's witnesses so that they can gain additional evidence to be able to satisfy Meister. The standard for, the Meister standard. I don't know shit, no facts here, do your own due diligence. This is just my snarky ass opinion on what I'm reading. In my opinion, that's what the defense is asking for. Okay, so at this point, right, we've proffered it. It might not be sufficient yet at the outset of trial, but we are requesting latitude in cross-examination of the state's witnesses to establish the additional evidence to satisfy the Meister standard. The court concludes that at this time, defendant's alternate perpetrator prop is inadmissible under Meister, as it is irrelevant and or excluded by IRE 403. However, this does not foreclose defendant from us examining law enforcement regarding the reasonableness of its investigation and its follow-up on plausible leads. So the court concludes that currently at this time, the time of writing this, defendant's alternate perpetrator proffer is inadmissible, but he is allowing them the latitude to cross-examine law enforcement regarding the reasonableness of its investigation and the follow-up on plausible leads. In other words, defense still gets to argue multiple perpetrators, multiple weapons. It has the standard here for Meister. Trial courts have broad discretion. Not Meister. I'm getting myself. Shut up, Annie. Just read. Trial courts have broad discretion in the admission of evidence. Carlson v. Harris, Idaho, blah, blah. A trial court acts within the bounds of its discretion when it, 1, correctly perceived the issue as one of discretion, 2, acted within the outer boundaries of its discretion, 3, acted consistently with the legal standards applicable to the specific choices available to it, and 4, reached its decision by the exercise of reason. Analysis. The case on the admissibility of alternative perpetrator evidence, Meister supra. Prior Meister, a defendant wishing to present such evidence at trial had to first present, quote, proof of connection with the crime, such as train of facts or circumstances, as tend clearly to point out someone besides the accused as the guilty party. Remote acts, disconnected and outside of the crime itself, cannot be separately proved for such a purpose. End quote. State v. Larson. Meister clarified that the Idaho rules of evidence, rather than the more onerous Larson standard, control alternative perpetrator evidence admissibility. Under these rules, evidence, if it has any tendency to make the existence of that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. State v. Garcia. Idaho Rule of Evidence 403 governs the exclusion of relevant evidence and permits a court to exclude evidence if its probative value is substantially outweighed by a danger of, quote, unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence, end quote. Meister further offered the following guidance on applying these rules and determining whether proffered alternative perpetrator evidence is relevant and admissible. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of IRE 403. A defendant has no right to relevant evidence, and even if evidence is relevant, it may be excluded in certain cases. The Idaho rules of evidence effectively safeguard against the admission of conjectural inferences without the lower courts needing to apply Larson direct connection doctrine. So even if the evidence is relevant, it could still be excluded in certain cases. And then State v. Meister, blah, blah. Here, the evidence defendant has proffered, according to establish the four individuals as alternate perpetrators, directly fails to meet the minor footnote. In addition, largely consists of inadmissible hearsay. Defends, however, that under Chambers, hearsay tending to establish third-party culpability may be admissible to protect a defendant's constitutional rights to a fair trial and to present a defense under the 6th and 14th Amendments. What Chambers actually held is that an accused has a due process right, exculpatory hearsay, meaning a confession by third party, provided it is accompanied by, quote, persuasive. The testimony rejected by the trial court here bore persuasive assurances of trustworthiness and thus was well within the basic rationale of the exception for declarations against interest. That testimony also was critical to Chambers' defense. In these circumstances, where may not be applied mechanistically, mechanistically, mechanistically. I can't say the word. I hate it when I do that. My brain won't say it. Mechanistically. To defeat the ends of justice. Motherfuck. In these circumstances, where constitutional rights directly affecting the ascertainment of guilt are implicated, the hearsay rule may not be applied mechanically to defeat the ends of justice. In other words, Chambers indicates that due process requires hearsay rules to bend to evidence directly bearing on the determination of guilt. It does not hold that unreliable evidence may be admitted simply because it may be relevant to the defense's case. As the court later stated, quote, "The accused does not have an unfettered right to offer evidence that is incompetent, privileged, or otherwise inadmissible under standard rules of evidence." End quote. So I wanted to read footnote 1 before we got any further and kept reading. That was footnote 1. Where did I leave off? Here we go. Namely, the evidence is entirely irrelevant. Nothing links these individuals to the homicides or otherwise gives rise to a reasonable inference that they committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. Sidebar, Your Honor, the entirety of the state's case is nothing but rank speculation and circumstantial bullshit, Your Honor. So if the state can fucking speculate, know what I mean? Just saying, rank speculation, nothing short of rank speculation. You mean like what the state is doing? Sir, 3 of the individuals were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicides, lived within walking distance of the crime scene, and were familiar with the layout of the victim's home from prior social events. We're going to stop here because we do have a footnote too, but it's probably redacted and I don't have to read it anyway. I just want to make sure. I don't think it is. Yeah, can't read it. Okay. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circle, no compelling evidence that any of them had a motive to kill the victims, much less physically harm them, or a means to do so. Sidebar, Your Honor. No compelling evidence that any of them had a motive. Where's the compelling evidence that the person accused had a motive? And what do you mean the means to do so? If you live within walking distance and all their friends played live action Fruit Ninja with fucking machetes, um, there's the means. You don't need motive, motherfucker. Why is he even mentioning motive? Why is he even hmm, I'll stop. Right. You don't need motive. I don't even know why he's mentioning motive. What's the motive for Kohberger? And please don't say jealousy. If someone says Kohberger's motive was jealousy, time them out. Someone tries to pop in and say his motive is because he was jealous, time them out. All right. It's just wild to me. So here he is, just with rank suspicion, right, about motive. These people had no motive. How dare you even suggest that they could be involved in the crime? What's their motive? We don't need motive, motherfucker, right? We don't need motive. The state doesn't need motive when accusing Kohberger. The fuck you mean the defense needs motive for alternate perps? What? Wild. Hippler's wild, bro. Further, There is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Searches of what? Searches of what? Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. A sidebar, it doesn't matter when all of the unknown fucking DNA still hasn't been tested as far as we know, right? It was never, nothing's ever been done with it. Lab testing has excluded their DNA from samples taken scene and the victims. Which ones? I mean, hopefully male blood B, male blood D, the hairs, fingernail clippings. You know, what pisses me off is that we're getting his opinion on the defense's proffer, and the problem with his opinion, for example, when he says dumb shit like he said before, like, I've seen no evidence that the state has relied on anything from 1125 Ridge. And yet, when you read the reports from the FBI agents, they're trying to identify the vehicle. They're literally telling you they're relying on 1125 Ridge and 451 Paradise Stills, right? So we can't, this is just this dude's opinion on what the defense proffered. I want to know, I don't know if we're going to get to see it, but I would like to. I mean, I don't see why we can't get it. Why isn't he putting out the proffer? You can redact names. If we get to hear his fucking opinion, his biased ass opinion on what they proffered, just put out the proffered stuff. Redact what you need to redact out the names that the defense is naming. What's the problem? We can't get the actual proffer, but we can get your opinion. Thanks, Hippler. Thanks, you dickhead. What the fuck? This guy's wild. He just makes me angry. He really does. Such a dickhead, you know? It's just wild to me. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches. Notably, lab testing has excluded their DNA from samples taken from the crime scene and the victims. The fourth individual, now this one's my favorite. The fourth individual, separate from the three. Anybody else notice his wording here? Right? That whatever the defense proffered, it's like these three are one group of alternates. This one might be an alternate, and the four are not connected. You got three over here, one over here. It would appear this fourth individual is on his own. Doesn't know these other three, doesn't know the victims, as we'll get into. Hopefully, you get what I'm saying here. Because these three, the other three cooperated. Let's look at this. The other three cooperated with law enforcement, provided DNA, fingerprints, and allowed searches. Notably, lab testing excluded their DNA from samples taken from the crime scene and victims. But look at the difference in language with the fourth individual. Did not know the victims, but had a quote passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. He followed her briefly out of the exit of the store while considering approaching her to talk. He turned away before even speaking to her. The event was captured on a surveillance camera. This individual subsequently cooperated. So it took him a little bit to come around and cooperate with law enforcement. This person subsequently cooperated. My guess is with a little bit of coaxing, with a little bit of, motherfucker, we're gonna need your DNA, or, we'll have no other choice than to look at you as though you're sus, right? And they go, good cop, bad cop. Like, if you don't give us your DNA, we have you on video, buddy. We have you following her around the store. You followed her out of the exit. And this person, too, clearly told the police, well, yeah, I mean, I followed her out of the exit and I was considering approaching her to talk, but then I changed my mind. And they're like, well, do you want to give us your DNA? And subsequently, this person cooperated with law enforcement, providing his phone number and a DNA sample. Okay. As with the other alleged alternative perpetrators, lab reports excluded his DNA from the samples taken from the crime scene and victims, and there was no evidence connecting him to the crime scene. So we know the fourth individual is definitely a him. It's a him. We don't know about the other three. What's this footnote? Here we go. Maybe did I miss it? Son of a bitch. There's footnote 3. Up in her, here it is. Lived within walking distance of the crime scene. Footnote 3. So what's this footnote 3 here? It says the fact that these individuals lived within walking distance to the crime scene is not probative evidence, given that the perpetrator drove a vehicle to the crime scene. Further, none of these individuals drove a vehicle matching the description of the suspected killer's car. Sidebar Hippler, what do you mean the fact these individuals drove a car? What do you mean the perpetrator drove a car? Given that the perpetrator drove a vehicle to the crime scene, sir, sidebar, that is not for you to decide. This man should not even have his mind made up. He is basically telling you in all of this, I already believe the state. Pre-trial. He is literally asserting here in his orders that everything the state has told me, I perceive to be a fact. Everything the defense has told me is a fucking conspiracy and rank speculation. And he's over here. This man is not supposed to have an opinion on what the evidence is. That is for the jury to decide, is it not? The fact that these individuals live within walking distance to the crime scene is not probative evidence, given that the perpetrator drove a vehicle to the crime scene. How the fuck? That is not a proven fact. That is not a proven fact. That is rank speculation on the part of the state and law enforcement when building their case. It's their speculation a vehicle was used. My guess is the defense's speculation is there isn't a vehicle used. It would appear the defense is alleging these people were on fucking foot, and the car is the red herring. That's just my opinion. I don't know shit. The car is the red herring. The defense and their experts are of the opinion these people are on foot. There isn't a vehicle you see fleeing from the neighborhood. Likely not the killers. Likely not the killers. Might be those two survivors, though, getting the fuck out of Dodge because of whatever they heard going on in that house. I understand the defense has said they never left the house, but then again, strategy is strategy, right? Sometimes if the state is saying they never left the house, well, okay, state, sure. You say they never left the house, fine. Okay, great. Yep. They never left the house, whatever you say. Know what I mean? Sometimes that's just how you got to play the game. So that was that footnote. Collectively, defendants' proffer with regard to these four individuals fails to give rise to even an inference that they committed the crimes or otherwise make it more or less likely that defendant was the perpetrator. Therefore, it is irrelevant under IRE 401. Defendant has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime that could possibly move the ball to the extent it supports an alternate perpetrator theory. Defendant has provided no probative, admissible, significant evidence of motive, ill feelings. Okay. What are the motives, the ill feelings of Bryan Kohberger, the person accused? Where's all that? Where is the state's evidence of that against the accused? At best, defendants' offer of proof can give rise to only wild speculation that it is possible any of these four individuals could have committed the crimes, which is inadequate under Meister. Again, quote, mere inferences that another person could have committed the crime will most likely not be relevant. In other words, it is not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all the defendant has done here. Eh, let us see that then, Hippler. Let us see what. So your opinion is, hey, everything you submitted was nothing but unsupported speculation, motherfuckers. You got no facts to back it. Okay, well then put it out then. Let the public see that they have nothing to back it instead of just your opinion of it. What's the problem? Let the public see it then. There should be no problem if what the defense presented was horse shit. If it's horse shit, you redact the names and let the whole world see it's horse shit. Why not? What's the problem? Instead, we just get his opinion, huh? Interesting. Let me come back to chat. Hopefully my shit's still working because I'm not even sure. I haven't checked back over here. I was in my other window reading docs, so sorry about that. Okay. Yeah, my chat's gone. I don't know what happened to my chat, friends. If I'm missing you guys, sorry. Who's here? Tonka, hello. Twiz, darling. Oh, hello, Twiz. Did I see AR back here? AR Hayes, what up? Welcome on in. My chat's being all wacky. Wacky to backy. All right. Let's get back over here. All right. Uh, in other words, it is not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all the defendant has done. And then this is my favorite part. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded by IRE 403. He always includes this in all of his shit. He did it with the Franks denial, their motion for Franks, when he denied all that. Even if there was evidence the FBI illegally entered the databases, even if there was enforcement, didn't do X, Y, or Z, even if the survivors waited 8 hours to call 911, none of it is probative or relevant or matters. Like, it's just fucking wild to me how he does this. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded by IRE 403. As the 10th Circuit noted regarding alternate perpetrator evidence, quote, it is not sufficient for a defendant merely to offer up unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice. Risk of jury confusion. Sir, this jury's been told that the defendant is an incel stalker fucking cannibal. Okay? That's what this jury's been told by the mainstream media for the last 3 fucking years, that he is an incel stalker cannibal. And now you're worried about jury confusion, fucking dickhead. Likewise here, and then he cites United States v. McVeigh. Likewise here, presentation of the proffered alternate perpetrator, great threat of confusing the issues because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. This foray would lead the jury astray, turning its focus away from whether the defendant, the only person whose actions are on trial, committed the charged crimes. Well, isn't that the point of presenting alternative perpetrator evidence, sir? Is to make sure the jury looks at someone else other than the fucking defendant? Isn't that the whole point? This foray would lead the jury astray, turning its focus away from whether or not the defendant did this. Well, isn't that the whole fucking point of third party culpability? What the fuck? It also presents a threat of unfair prejudice as it would invite the jury to blame unrepresented persons for a heinous crime when there is not a scintilla of competent evidence connecting them to the crime, more than waste the precious time of the jury and the court in what is already a 3-month trial. Nonetheless, the court's ruling does not preclude defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in following up on and ruling out leads generally. Indeed, the Idaho Court of Appeals recently found in an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to alternative perpetrator analysis. Quote, we agree with Emerson that a relevant line of inquiry would be to question the scope and breadth of the investigation and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked. Bam. Thank you, Hippler. Even though I think you are an absolute dickhead, thank you. Because I'll say it again. This right here also means the defense and their experts will absolutely still be arguing multiple perpetrators, multiple weapons, and they will be able to explore on cross-examination whether plausible investigative leads regarding third party were ignored or overlooked. I cite State v. Buck, blah, 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 blah. It further stated that this line of questioning may not include inquiries about the specific third parties absent satisfying Meister, which the defense has already said this is why they want a lateral cross-examination. They want to be allowed to do this, right? Because they want to question these officers and these detectives in hopes of gaining the evidence they need to satisfy Meister. In which case, then they can actually start talking about very specific third parties and naming names. They have to satisfy Meister first, right? I don't know shit, don't listen to me, but I think I'm right about that. Satisfying Meister, noting, while evidence challenging the thoroughness and reliability of the investigation might be probative, questioning whether law enforcement investigated specific individuals with no connection to the murder provided no probative evidence. Moreover, with no connection between the evidence and the crime, there is no explanation or justification for the questioning, and it would not help the jury answer the only question in the case, which is whether Emerson killed James, or i.e., whether Kohberger killed these 4 people, right? So until you satisfy Meister, you can't be bringing up people's names. However, you can laterally cross-examine the state's witnesses, including law enforcement and the detectives, and hopefully, maybe you can establish some evidence that you need to meet the Meister standard. Hippler is going to allow that. The court will apply these same parameters at trial regarding defendant's cross-examination of law enforcement. He may inquire as to the reasonableness of the investigation, including investigating and ruling out other leads. He is not, however, permitted to question law enforcement about the investigation of any specific individual as a potential alternate perpetrator without first raising the matter with the court outside the jury's presence. Right. Outside the jury's presence. That means sidebar, Your Honor. A side, right? So they will have to raise the matter with the court outside of the jury's presence. So the court will apply the same parameters at trial regarding defendant's cross-examination of law enforcement. This is why Hippler is saying that at this time, the alternate perpetrator standard has not been met for Meister, correct? At this time. But they're still going to be given the opportunity to meet it through rigorous cross-examination of the state's witnesses, is what I am gathering from all of this, right? And yet again, and it is what it is. The fact of the matter is, all of this basically still means the defense and their experts still get to argue multiple perpetrators, multiple weapons. So, all right. Let's see here. Okay, so we got through all of that, right? Yeah, blah, blah, cool. Stop sharing that. I don't even care about this motion to continue, not even gonna lie. I don't know about the rest of you, but I don't even give a fuck. We all know he denied it, right? Because as we for when the trial is going to start, the date for when voir dire is going to start. So it looks like everything's been pushed out by like a week anyway, as the motion to continue is denied. It looks like, I mean, it's been continued out for at least a fucking week as of right now, right? That could change. Looks like everything as of right now has changed, though. And we'll go look at that somewhere in here. I saw it somewhere. Amended scheduling order. There it is. Let's go look at that real quick, in case anyone hasn't seen it. Let's share real quick. My chat's gone, guys. Sorry. Here it is, but it's gone. Love you all. Appreciate you for being here. My chat on my end on Restream is gone. I can't see you. Can't see your comments. Hopefully, you guys can at least see this shit, though, and hear me. All right, so we have the here. This is why I was saying it looks like things have actually hit. Even though he's saying that the motion to continue was denied, looks like it was semi-continued. We got a semi-continuance, maybe. Court's prior scheduling order is amended as follows. Sealed proceedings with the court and counsel will take place. Sealed proceedings with the court and counsel are going to take place July 28th, August 1st. Wonder why. Couple days of sealed proceedings with court and counsel before voir dire. Voir dire will start 3 days later on the 4th rather than July 30th. So it looks like everything's been pushed out due to whatever these sealed proceedings are going to be. He's kind of pushed things out. Voir dire is going to commence on the 4th rather than July 30th and continue until a jury is seated. It is estimated that the trial itself, beginning with opening statements, will commence on August 18th and continue until completed, but yet everything we read out of those PA and subpoenas said that the trial was going to start August 11th. Now that's been pushed out a week. So trial's been pushed out a week. voir dire was pushed out 4-ish days, and it looks like maybe it's because of whatever's going on for these sealed proceedings taking place July 28th through August 1st. I could be wrong, but I'm wondering if that's maybe why it was all moved around. So, stop sharing that. All right, guys, what I'm going to do is we've all read the motion to continue. Everybody's read it, right? I don't need to read it. Everything is freezing. I can't see my chat. Everything's giving me a problem again, and I don't know why. So, what I'm going to do is I'm going to end this shit. I know that I titled it Motion to Continue. I'm going to retitle it. Nobody thinks they got duped into clicking on the video. It's not that motion to continue. Fuck Hippler and fuck Idaho about that. It was continued. Wasn't continued for long, but the trial was at least continued out for a week. So, haha, it was continued. Beep, beep, bitches. That's what I got to say about that. So, I love you all. I can't see my chat. I have to get up very early tomorrow. Let me get my phone real quick and see if I can bring it up on my phone because I at least want to be able to interact with chat and read you guys' comments, even though I can't see it on my stream, like on my end anyway, for restream. Oh, I can see my mods too if I do it this way. Okay. So, yeah, no, Lori Jean, please don't even worry about it. Go put your chickens to bed and do whatever you got to do. I'm about to dip out of here myself. Hopefully, it wasn't too bad, guys. I hope my audio held up. I don't know what the problem is. Maybe it is just the solar flares. But I'll retitle the video. Fuck that motion to continue. It was continued. Don't let anybody tell you it wasn't. And we that the motion to continue was denied, even though Hippler's saying it's denied. It wasn't because to push trial out a week. Beep, beep. And thank you, everyone, for your super chats and your cash apps and for contributing to the gas fund. I will run PA as soon as we can. Probably do a quick little live night before the hearing, nothing too crazy. And once the hearing is done for the day and I get to the hotel and I'm settled, we'll do a recap of everything that happened at the hearing. So, love you all. Happy Friday. Going live. Lana will be live. I think there's going to be lots of people live tonight. And yeah, go have a safe Friday night. Thank you so much. Appreciate you. See y'all soon. 2 more sleeps. We're in PA. Bye.